Welcome to this morning's In-House in Focus webinar. Today we're looking at contract disputes. We're focusing on 5 key areas that generate litigation. If you don't know me, I'm Rachel Higgs. I head up one of our commercial disputes teams, and I'm joined today by Simon Pedley and Doug McDonald, who also head up commercial disputes teams in 2 of our other offices. This session is being recorded. The recording plus the slides that we'll be using in this webinar will be sent to you in a couple of days' time. So you don't need to, well, by all means, scribble notes, but you will get the slides and you will get the recorded session very soon afterwards. If you have any questions during the course of today, if you could put them in the Q&A box at the bottom of the screen, we'll try and answer those as we go along, but if we don't get round to answering all of the questions, by the end of the session, then we will try and contact you after the event individually to answer your questions. If you identify yourself, then we can follow up. You'll get a survey form at the end of the session. Please do complete it so that we can follow up on your comments and on your suggestions for topics that you'd like us to cover in future webinars. We'll aim to speak for about 40 minutes. We'll try and leave a little bit of time for mop-up questions at the end, although, as I say, we will try and take questions as they come in, and we'll cut off pretty promptly at 10:45. So looking at our agenda this morning, if we could have the next slide, these are the areas we're going to cover: defective drafting, notice clauses, earn-out provisions, material breach, and contract management post-acquisition. Now, I'm conscious of the fact that there are quite a few in-house lawyers who work for public sector organisations here today, and you may be looking at some of those or 1 or 2 of those and saying, well, I'm not sure that applies to me. The general principles that we'll touch on in all of those sessions will be of use to anyone who's involved in contract drafting, or at least we hope it will be of use to anyone who's involved in contract drafting or indeed contract litigation. So I will kick off by looking at the first of those, which generates, in my experience, oodles and oodles of disputes, which is defective drafting. So let's start with a poll, if we could get the poll up, Kate. Right. Have you ever had an argument with another party to a contract that arose because of defective or clumsy drafting? Now, it might have been an argument about what the clause in the contract actually meant, or an argument which couldn't be resolved by looking at the contract because the contract was completely unhelpfully silent on the point. So yes or no to that, and then how did you resolve the argument? You backed down, they backed down, you compromised. Oh, we haven't got the last one, at least not on my screen. The last one was you litigated, but never mind. Hopefully not many of you did. You backed down, they backed down, you compromised. Maybe there is a question under there that I can't see on my screen, but I suspect if you can't see it, then I can't see it, then you can't see it either. So let's have a look. So, okay, Kate, shall we end the poll there? We've got some numbers there. And if you could, is that the sharing the results? Okay. So yes, 94% of you, no, 7% of you. That's interesting. That adds up to 101. How did you resolve the argument? You backed down. Not many of you backed down. Interesting. They backed down, you compromised, and did we have a litigate? We had a few who litigated at the bottom, but mainly you ended in compromise. Well, that's very sensible and probably what most lawyers would advise you to do, because those sorts of disputes are incredibly difficult to predict in terms of outcome if you take them to court. Thank you. Sometimes, of course, I suppose the starting point is to say this. Sometimes, of course, ambiguous drafting can work in your favour, but more often it sours relationships and it generally puts quite a lot of money into the pockets of litigation lawyers like me. So let's have a look at a recent case. If we could get the next slide up, Kate. I need to get rid of this poll. Close the poll. Right. Let's have a look at a recent case which hinged on what the Court of Appeal described as clumsy drafting. The decision last year in Nord-Naphtha Limited against Newstream Trading. Brief outline of the facts I put up on the screen. So the claimant placed an order with the defendant for the supply of diesel, made an advance payment of $60 million. Defendant placed an order in turn with a refinery in Russia and paid most of the advance payment to the refinery. and in return, the refinery issued a comfort letter to the claimant. Then the refinery subsequently had operation issues, couldn't supply. Defendant used a force majeure clause to terminate the contract, and rather unsurprisingly, the claimant then sued for recovery of the advance payment. Unfortunately, there was nothing in the contract which expressly said that if the contract was terminated in force majeure circumstances, then the claimant was entitled to its money back. But buried in the force majeure clause was some wording. If we could get the next slide up, please, Kate. Next slide. That's it, contract wording. In case of termination of the contract, by reason of a force majeure event, nothing herein shall impair the obligations by the seller to repay to the buyer the amount of the advance payment under this contract in the event that the delivery of the product is not made or only partially made due to force majeure event. Now, there were a number of arguments in this case, but the main argument was whether the words up there created an obligation to repay the advance payment, which didn't appear anywhere else in the contract, or whether it merely preserved a right to repayment that appeared somewhere else in the contract. And needless to say, of course, the claimant contended that it created an obligation to repay, and the defendant said, no, it merely preserves a right to repayment if one exists elsewhere. And because the contract didn't spell out an obligation to repay, then the defendant wasn't obliged to do so. So the defendant said, you must look to the Russian refinery under the terms of the comfort letter. So let's have another poll. If we could put up the next poll, Kate. Did the wording, nothing herein shall impair the obligations by the seller to repay to the buyer the amount of the advance payment, create an obligation to repay, or merely preserve a right to repayment if the buyer could establish such a right, for example, by reference to an express term or an implied term in the contract? So create or preserve, what's the view on that? That's interesting. So at the moment we've got quite a strong majority in favour of mere preservation. Okay, we can end that poll, Kate. I think we've got the flavour of it, as it were. Merely preserving a right to repayment. Actually, the court were more sensible, perhaps, than you're giving them credit for. They said that wording created an obligation to repay. So if you could get up the next slide. I just get rid of that poll, summarised the Court of Appeal's approach to contract interpretation in this case. And there was nothing new in this. It echoed a line of cases going back about 25 years where more or less the same sort of thing has been said. So in terms of approach, the court must ascertain the objective meaning of the language chosen by the parties, looking to understand what a reasonable person would have understood the parties to mean, i.e. a non-lawyer, such person having the background knowledge which would reasonably have been available to the parties when they formed the contract. If there are two possible constructions, clearly there were here, the court's entitled to prefer the construction which is consistent with business common sense and to reject the other. But in striking a balance between the indications given by language and the implications of the competing constructions, the court must consider the quality of the drafting and must also be alive to the possibility that one side may have agreed something which with hindsight did not serve his interest. So, next slide, if we can get the next slide up, please, Kate. Look at the courts, how they then applied that principle to the facts of this case. Probably, I have to say, influenced by the fact that the letter of comfort issued by the refinery had arguably expired by the time of the events in question, so that would have left the claimant with no recourse. The Court of Appeal went on to say, following the wording on the screen, on a fair reading, and one which a reasonable and informed observer would adopt, the words "nothing herein shall impair" are not the operative words in this clause. They're merely an introduction to what follows, which are the words the obligations by the seller to repay to the buyer the amount of the advance payment in the event that the delivery of the product is not made. The more natural reading of that clause is that it creates and confirms that the seller is obliged to pay the advance if the goods are not delivered in force majeure circumstances. So if you could have the next slide, Kate. They also looked at the commercial context and said any reasonable and informed person coming to this contract might well adopt the starting point that it would not make any business sense for a buyer to enter into a contract which lacks a right of repayment of the advance in force majeure circumstances, which is no doubt right. I mean, I have no doubt the person in the street, as it were, when faced with these facts would say, well, of course the claimant should get their money back. So I have to say, simply looking at the position of the claimant and the defendant and ignoring the possible right of recovery against the Russian refinery. So what general principles can we discern from that case and indeed the cases that led up to it? Well, if we could get the next slide up, in my view, the court's current approach, and I think this is here to stay, as it were, I can't see this being easily changed. It can be summarized in this way. Where the language used in the contract can bear more than one meaning, then the court will seek to ascertain what a reasonable person would have understood the contract to have meant at the time it was entered into in the light of the relevant background facts. Having looked at the relevant factual background, if there are two possible constructions, the court is entitled to prefer the construction which is consistent with business common sense. But the court won't impose on the parties its own view of what's sensible, where the contract has a clear meaning, even if that meaning doesn't make the most commercial sense. So if the contract wording is clear, then that clear wording will be taken to be the meaning the parties intended, and the court won't interrogate or be particularly interested in what the parties actually intended. And then there are two further points, if we could have the next slide, please, Kate. So if the mistake was not in the language, but in failing to anticipate the consequences of the contractual provision, then the court won't intervene. So if you've got a straightforward clash, a battle in terms of two competing constructions, then you can expect the court to step in and they will apply business common sense. But if you've got clear wording, then it doesn't matter that it then results in an unfair result. The court won't intervene. But that final point, if it's obvious by looking at the contract as a whole that something has gone wrong with the language and a reasonable person would understand the parties to have meant something different, then words can be rearranged, they can be inserted, they can be ignored, poor grammar, punctuation overlooked in order to resolve the ambiguity. I think the message from the court really is this: if you draft with precision and clarity, then your words will be given that unambiguous meaning, even if they don't reflect what the parties intended. But if you draft imprecisely and you use confusing or equivocal language, then the courts may rewrite your words to make business common sense. But of course, you can't be sure that they're going to decide in your favour. And so that is not a terribly satisfactory position. So what I want to move on to is probably the slide which I hope will be of most use, which is sort of drafting tips, taking all of this into account. Some of these more obvious than others probably. Where possible, use clear language that's capable of one, hopefully correct interpretation only. Set out the background to the contract and the parties' intentions in entering into it in the recitals, if that's appropriate. Hugely importantly, use clear and consistent definitions. I haven't bored you with a bit of this, the Nord Naphtha case, which actually had some wording, capitalized wording, referring to an outstanding advance payment, which meant absolutely nothing because it wasn't defined. And I see that time and time again. I've lost track of the number of cases where I've seen terms in capitalized letters which then aren't defined. So make sure that particularly where you're using terms that have a particular meaning in a particular industry, that you spell those out in a definitions section. Where there's a conflict or tension between contractual provisions, spell out the order of precedence that needs to prevail. So subject to clause such and such, or in the event of, then clause so and so is the priority. Take particular care with termination provisions and the consequences that will flow from a failure to adhere to the terms of the contract, and make sure that the consequences of the force majeure event are clearly stipulated. Now, I've got two questions before I pass over to Simon. Rachel, how would UCTA play against this drafting issue? Sorry, Dean, but that will take me quite a while to explain, and is probably the subject of another in-house advisors seminar. So in the interest of time, I won't answer that. But yes, of course, if you are in UCTA territory, and you can point to clauses being unreasonable under UCTA principles, then that would come into play without a shadow of doubt. And I've got another question. Does the recent case law you discussed contradict the principle that ambiguous drafting will be interpreted against the drafter? Now, that's an interesting question. A lot of us have got that in our minds from sort of law school days, the contra preferentum rule. And actually, in my experience, that doesn't get you home very often. That's a weapon of last resort. And I certainly would not trust to that. Far, far better to be explicit in your drafting and to make sure that your drafting actually covers the point. And in particular, I mean, if there's one type of drafting error that I could point to as being the thing to have in mind, it's spelling out the consequences of a breach. Simon will probably come on to this, but spelling out the consequences of a breach, not just setting up there to be a finding of liability, but spelling out what should flow from that. And that's probably something that's best done in consultation with your commercial colleagues when you sit down and work out what it is they're trying to achieve from this contract. What constitutes a serious breach and a minor breach. And as I say, Simon will come on to that later. So I will pass on that note to Simon.
Thank you very much, Rachel. I should say at the outset, Rachel asked me before, am I sitting in front of a shower? No, I have not come into my bathroom for some peace and quiet. That's the office building over the way. So notice clauses, right. Well, let me start with a very sad story, a very salutary lesson about an unfortunate lawyer. This lawyer was not me. I've not gone through the whole list, and I would sincerely hope it's none of you. It was, in fact, a colleague of my wife's at a firm she used to work at. So this is 15, 16, 17 years ago, something like this. This was under an SPA, and a very important notice needed to be served. I don't even know what it was. It was notification of a warranty claim, which had to be given by a certain date or something like that. And this lawyer, being very diligent, thought, great, I want to be extra sure that we serve this notice, and so arranged for it to be served by some form of guaranteed signed for overnight courier. Sadly, this lawyer did not check the contract. And after this notice was served, the other party came back and said, sorry, the contract says you've got to serve me by first-class post. You've not served me by first-class post. Therefore, I've not received a notice. Therefore, you've not got your warranty claim. Complete disaster. The firm's insurers were involved. I don't know how it got resolved. But that's the sort of issue that crops up a lot in the disputes that then end up on our desks. So notice clauses might seem a bit like boilerplate that's not very interesting, but it is important to really think about them when you're drafting them and when you're purporting to give some sort of notice. So what sort of clauses are we looking at? I mean, it's big things like termination of a contract. You've got to serve termination by a certain date, or the contract rolls over for another year. So big consequences if you miss it out. You get similar contracts in leases, or like I say, notice of warranty claims, things like that. And the point of these clauses is actually to provide commercial certainty, is to be unambiguous along the lines Rachel was just talking about. So there isn't a dispute. It's not necessarily about, is a notice brought to the other party's attention? That's part of it, but it is, has this procedure been followed? And have we got commercial certainty? What then flows from that? I'm not looking at court rules, what that says about service. It's a slightly different position. And in fact, there was a recent case which said signed for first-class post is the same as first-class post for the purposes of court rules. But we're not looking at that. And I'm not looking at specialist things like property or construction. Do be aware there are some statutory provisions which apply if a contract is silent, or sometimes which work in tandem with it. So Companies Act about serving at a registered office. There's stuff in the Law of Property Act. There's stuff in the Landlord and Tenant Act, but I'm not going to go into that. So what are we going to consider? We're going to look at, how you would serve the other party, who at the other party you should serve, getting consistency between different documents in a suite of contracts, and what sort of communications do you actually want to be subject to these clauses? So if we can move on to the next slide. Here's some of the obvious methods. Email, serving formal notice by email. There's a lot of dangers with that, particularly in terms of practically, does the notice actually get through? What if you mistype the address? What if the recipient server goes down? What if it's caught in someone's spam filter? What if the individual whose email address you've got has left? I mean, all these sorts of issues. So by and large, it's to be avoided, but it might be, if it's only for a short period of time that the relevant contract is in play, it might be if you've got someone who's overseas or whatever it is, the email works, but by and large, it's good for day-to-day communication. You just got to be careful if you're doing formal notice. Post is the obvious way to do it for any formal notice. We'll come on to cases where the court says they really strictly construe these clauses, so you've got to be careful and do it right and do it by the right form of post, but that tends to work. But then there can be issues about the address you serve it on. Has the other party served you notice of change of address and all that sort of stuff? And we'll look at that very briefly. Personal service is always possible, and it's good, and the proof of delivery is the person who served it doing a statement saying, yes, I posted it through Mr. X's postbox on, letterbox on such and such a date. Be wary with these about being over prescriptive, because if you say it must be to serve a notice, I must hand it to Doug, that's all well and good, but then that means if Doug's out, posting it through his letterbox won't be good service. Handing it to Doug's wife to pass on to him won't be good service. So just be careful about being over prescriptive there. Fax and telex, I just say be wary of any old contract you've got. I mean, I can't imagine anyone puts anything like this in before, and I'm not sure we've even got a fax number. We've certainly got no fax machine. And foreign parties, just be wary of that. Are you going to ask them to provide an address to service of notices within the jurisdiction? Are you going to do the email stuff? So that's one just to be careful about. So if we can move on to the next slide. Tying into how you manage a contract on a day-to-day basis, Doug will be looking at that later, but then about if personnel change, if people change, and it's making those communications happen properly between the two parties. Dealing with change of personnel, it would generally be better to say notice must be served on the managing director of the other party rather than on Mr. X, who currently happens to be the managing director, say. And you've got to have provisions about notifying of change of address and all that sort of stuff. And then I suppose you have to consider, does a notice of change of address have to be served formally in accordance with the notice clause under the contract? But again, keeping track of this, because if someone hasn't formally notified you of a change of address, but they've moved, that leads into problems. And there's a very salutary case about that, which is Zayo Group International Limited v. Ainger 2017 case. And this was one where it was, again, notification of claims under a sale and purchase agreement. And there were 7 sellers or management sellers who could be sued. And the contract said you've got to serve notice on every one of the 7. And if you miss one of them, then the notice is invalid and you haven't got a claim against any of them. And the court held here the claimant hadn't served this notice on one of these defendants. The courier had turned up to the address. It became rapidly obvious that the relevant individual hadn't lived at that address for a while, even though that was the one in the contract. And so the courier went off and then went to one of the other defendants and passed on the contract for handing over to that defendant. And the court said, sorry, that's not good service. The contract said serve it at a particular address. You didn't. Using some of those points Rachel was trying to talk about, they said, oh, there should be a term implied that reasonable efforts to serve at the address specified counts as good service. And the court said, no. Now, every contract has to be construed on its own terms. There's no hard and fast rule. It's a matter of contractual interpretation in the round. But you've got to be so careful, as my wife's former colleague found out, and as was the case here. So these are really important.
Simon, can I just butt in there with a question that's been raised?
Please.
I'm assuming here that what's said in the contract is that notice has to be served at a particular address, which is the registered office of. When the question is, when changing registered office on Companies House, do we need to notify everyone we have an agreement with to let them know to ensure that any potential service is served correctly? What's the best way to manage this? So what happens if you if you want to change the address, it could be the same would apply presumably to an individual who's moved address.
Yeah. It depends what the particular contract says. So, whether a change of address at company's house amounts to sufficient notice of a change of address under that contract depends on the terms of the contract. But as a matter of good practice, yes, if you've got contract with people and the address you want to be served at has changed, then you need to notify them in accordance with the terms of the particular contract. It would be very unwise to rely just on company's house if that's not what your contract says. If your contract simply says you'll serve it on our registered office from time to time, then yes, change of your registered office at company's house will be good notice, and it's for the other party to check. But if the contract says you must serve it on our registered office at 123 the High Street, then you just need to be careful and look at every contract on its own. So as with any contract management, it's the big high value ones, it's the strategic and critical ones. You want to have a look at them on any of those situations would be my answer to that.
Presumably it would help to have wording in the contract that says serve at this address or any address that this particular party notifies you subsequently. Yes,
but that's the issue of then them formally notifying you of that change, and that's down to the day-to-day ongoing contract management and the sort of points Doug will hopefully be looking at. You've just got to be on top of the contract management, and so these clauses are important because getting it wrong can have such catastrophic consequences. So thanks. So very quickly, I'll finish off on my last slide because I know I'm running over slightly. I've made the point, strictness of construction. The House of Lords case, Manai Investment and Eagle Star in 1997, the court made the point there, well, in some contracts, if it says you must serve notice on pink paper, but in fact you serve it on blue paper, that might not be valid notice. But you do construe these clauses in line with normal contractual construction on the basis of the principles Rachel was talking about. In that particular case, they found that even though someone had mucked up service, that was still valid service. It was slightly tortuous reasoning, but it was under a lease. So I'm serving notice of termination of this lease. And if they had said to take effect on the 2-year anniversary of the grant of the lease, and it said that and they'd served it, it was fine. In fact, they tried to specify the date and said, I give this notice to expire on the 12th of January. And it should have said 13th of January. But the court managed to find in that case that construed as a whole, that was valid service. But it just emphasizes the point. You want clear drafting, you want contractual certainty, and then everyone knows where they are. If you don't do all that, then it's great for us doing this seminar because we're the litigators and we have fun trying to sort it out. But for you, managing the contracts, it's a bad idea. And I'll just say, deemed service, be clear when you're drafting these clauses under the various forms of notice, when is notice deemed to occur, and then thinking when exercising it, be cognizant of that. So if it's deemed service will take place 2 business days after posting, you need to make sure you're doing your bit 2 days before the relevant deadline, rather than doing your bit on the deadline and then you're serving 2 days late. And just finally, belt and braces, if you're doing it, serve it strictly in accordance with the contract, but there's absolutely no harm in then emailing it to everyone under the sun to make it absolutely clear that the other party actually had notice, actually received the notice, but don't do that at the expense of serving in accordance with the terms of the contract. Sorry, I slightly overran. Over to Doug.
Thank you, Simon. Good morning, everyone. As Rachel mentioned at the outset, I'm going to talk about earnouts, and this is one area that might not be relevant to everyone, but the principles that I'm going to talk about will apply to every contract. What is an earnout? An earnout is when the shares of a company are being purchased and there is a mechanism whereby the purchase price is wholly or more usually determined by reference to the post-completion performance of the company. For example, the initial consideration may be £5 million paid at the time of the purchase, and it is agreed in the contract, i.e. the share purchase agreement, that a further £3 million will be paid 2 years after completion if certain profit levels are met. The classic earnout is normally calculated by reference to profit level over a 2 to 3 year period after completion. It is less typical, but it is possible to link the earnout in terms of the deferred payment to other financial or operational benchmarks, such as turnover, net assets, number of new customers gained during the period. The key advantage to earnouts is that they can bridge the gap between the seller wanting as much money as possible based on the future potential of the company and the buyer wanting to pay as little as possible in order to mitigate the risk that a business might not live up to its promise. If the trigger for deferred payment is linked to hitting a certain level of profit, then you would think that the parties' interests are aligned, i.e. they're trying to maximize the company's profit during the relevant period for both of their benefit. In which case, it should all be fairly clear-cut, you would think. However, the parties' alignment is fairly superficial. Despite there always being some form of contractual metric to measure the performance, earnout arrangements are an area that often lead to disputes. I currently have several of them on my desk right now. If I could please have the next slide, Kate. I'm going to refer to 3 different areas that will lead to disputes. And as mentioned, I have several of these matters on my desk right now, and they all involve one or more of the following issues. A key message at the outset is not to underestimate the importance and the time that you should commit to ensuring that the drafting of the mechanism in the contract holds up to scrutiny when considering all of the different permutations that could arise in the future. The first issue I'm going to mention is representations during the negotiation process. We all know that negotiations are often emotive, high-pressured, and fast-moving. Many statements and assurances are made by both parties. And if you are to rely upon one of those statements to your detriment, you may, and it's a big may, you may be able to bring a claim for misrepresentation further down the line if you've suffered loss. Misrepresentation is a topic in itself, and I'm not going to get into it today, but I want to highlight that the court draws a very clear distinction between misrepresentation and a mere statement of opinion which proves to be unfounded, or mere sales puff, as they refer to it. Sales puff has no legal effect. But as we all know, there can often be a lot of sales puff and big talk during a corporate transaction. So do not assume that you can rely upon those statements made, even if they are made specifically in relation to the earn-out mechanism. Whilst a claim in misrep might be an option, you'll often be starting on the back foot if, for example, there is an entire agreement clause in the contract. Another key message is that if there is a term that is so important to you, then you should put it in the contract. The second issue relates to the conduct of the parties, but mainly the buyer, during the earn-out period. This is the period immediately after the acquisition and the relevant period for measuring whether the earn-out threshold will be met. You often have an entire schedule in the contract dedicated to the conduct of the parties, but I have seen many cases where those what appear to be boilerplate clauses or schedules have been limited or removed entirely. This will leave the selling party exposed. The main point in relation to conduct during the earn-out period that I'd like to make today is that please note there is no implied general duty of good faith under English law. Do not assume that the buyer must act in a certain way during the earn-out period. This is particularly important when dealing with a party in a different jurisdiction. For example, there is generally an implied duty of good faith and fair dealing, which is engaged into contracts in America, but this is not the case in England. So again, if you want it, then put it in the contract. Another point to mention is that if you are on the selling party, make sure that you actually have access to the relevant financial information and documents that you will need to measure whether the numbers are being hit or not. The third issue relates to not making assumptions in relation to the metric being used to measure whether the profit level has been hit or not. You would think if you are pegging it on profit, it should be the straightforward bit, because you'll have the metric and you'll have a formula as to what the threshold has to be. But how truly objective are those measurements? Remember, to a certain degree, accounting can be an art form. It involves principles and numbers, but there's always a degree of judgment involved. Even if you do have an entire schedule dedicated to measuring of performance, and when the deferred benchmark will be triggered, you need to ensure that you've read it carefully and you've actually stress tested it. Do not assume that just because it references EBITDA and general accounting principles, GAAP, that there will not be a dispute when it comes to payday or not having a payday. By way of example only, does EBITDA cover exceptional items that have arisen as a result of a global pandemic, either good or bad? If it refers to generally accepted accounting principles, is that the UK version or the US version or another jurisdiction? There are also many other factors that are involved. For example, writing off bad debts or large investments in future infrastructure of the company, if they are made during the earn-out period, that will impact on the bottom line and then the threshold. So a top tip here, and I appreciate, it does depend on time, but take the time before you sign the contract to stress test the earn-out schedule, including the conduct provisions during the period, the threshold and the measurements, particularly if the other party is based in another jurisdiction. Also, ensure that your relevant internal finance people and potentially external finance people are involved heavily in negotiating and agreeing the earn-out mechanism. Because after you've signed the contract, it's too late to try and challenge those metrics when you don't get your payday, for example, 2 years later. That was a bit of a whistle-stop tour on earnouts, but obviously if you've got any questions, please do put them in the chat function. I'm going to, I think, pass back to Simon now, I think, to take on the next topic.
Thank you, Doug. Yeah, I'm looking at contracts where it provides you can terminate for material breach or terminate for repeated breach and those sorts of things. And these are a very fertile source of disputes. One of my cases, best part 10 years ago, which made it to the Court of Appeal, in fact, on a question of contractual construction, a la the case Rachel was looking at earlier, where in fact I lost, and I still feel very hard done by on that. I think the Court of Appeal got it wrong, but there you go. But this was a case about a convention centre which terminated the contract with its catering provider halfway through the term of the contract. And the contract provided you could terminate for repeated breaches. And I advised, well, there are enough breaches and they are probably taken together serious enough that you can justify termination, but the clause was a bit ambiguous, and I said you can do it, but be prepared to be sued, which in fact was the case, but they needed to get out of this contract. And so these sorts of termination clauses are very important to understand and get right, because if you get it wrong and you purport to terminate when you don't have a right to terminate, then you yourself can be the one who's in repudiatory breach of the contract and the other party can sue you. And there's a case, I'm not going to talk about it, but last year's CIS against IBM, where IBM purported to terminate this contract for non-payment of an invoice, a smallish invoice by Co-op, by CIS. And Co-op argued successfully that was repudiatory breach, that termination. They accepted the repudiation and they went on and sued IBM for all their wasted expenditure on this disastrous IT project. The moral of that story is the lawyers did very nicely out of it, but none of the parties ultimately did. So you want to try and avoid putting money in our pockets by getting clarity, particularly around these sorts of things. Because remember, at common law, only the most serious breaches will justify termination. So if we can go on to the next slide, please. So when looking at contractual clauses, courts will generally hold that material breach is something less than repudiatory breach of common law. Otherwise, why have the clause if it's just the same as your common law right? So at common law, if you remember, you can breach for a condition of the contract, a term so vital and central that its breach allows you to terminate, or you can terminate for repudiatory breach of an intermediate term, which is a term somewhere in between a condition and a mere warranty. And frankly, these days, the courts mostly will say most terms are in intermediate terms, and then you have to look at the breach. Does that breach substantially deprive the other party of the benefit they were hoping to get out of the contract, that sort of stuff. And the court will judge it as at the time of termination. Was the breach serious enough? Not 2 weeks later, were you proved to be right, but at the time you terminated, did you have that right? And so the sorts of thing the court expects you to look at, and similar things will be relevant when you're looking at, has there been a material breach of a contract? What benefit would you have got had the contract been performed properly? How much have you already received? What loss have you suffered? How does it affect future performance? Has the breach been repeated, continued, remedied, so on and so forth? How might that continue? But looking at what is a material breach justifying termination under contract, there is no strict legal definition of a material breach means this. It depends on how you construe the contract in the round, in accordance with those principles Rachel mentioned earlier. And material, depending on the context, could just mean not trivial, or quite a low threshold, up to serious enough to justify termination of common law, i.e. repudiatory. What does material mean? There's a huge spectrum. A lot of decisions take, as you might expect, a bit of a middle ground. So, for example, Lord Justice Jackson in Compass Group and Mid-Essex Hospital in 2013 said in that contract, material breach was one which is more than trivial, but need not be repudiatory. So what that tells us, I don't really know. So some contracts then add definitions as to what material breach might be. They can be helpful, but you've got to be really, really careful with them, because unless they're well drafted, they don't help. You might probably be better advised to say material breach will include, but is not limited to X, Y, and Z, and then you give some examples of things you would regard as material breach, and that helps give some definition and structure to enable the parties and then the court to interpret that contract. Termination for substantial breach, the case is substantial breach, material breach is a similar kind of thing. So if we can then go on to the next slide, we're looking at this question of repeated breach, terminating for repeated breach. Now, common law, just compare contracts to common law. Common law is, do all these breaches taken in total amount to a repudiation? If they don't, but you still want to be able to terminate, you must have a specific contractual right. You must put something in your contract. And there are various clauses, all the PLC and other precedents will have appropriate clauses which try to give some structure to this. If you want to be allowed to terminate for just accumulated but minor breaches, nothing particularly serious, you've got to be very, very clear. Because again, looking at construing contracts, business common sense, terminating the whole contract for a few minor breaches is quite a big thing, which might be held to be contrary to business common sense. And so you've got to be super, super clear if you want to do that. You can do it, but absolute clarity and drafting is required. One thing you could do is, of course, have some sort of point system KPIs. I looked at an accommodation contract for a university client which wanted to know, could it terminate against this provider? And ultimately, the advice was, well, no, you can't, because this contract provides a point system and you have to accumulate so many points over a set period to even get a reduction in the price, let alone terminate. And that was actually quite a salutary example, because though these systems are good in theory, in practical terms, the accommodation provider would have to have been so diabolically bad at the contract for there to be any adverse effect, even on price. Even though it was pretty shonky and was doing things in a slapdash way and it wasn't great, that clause didn't work through. It hadn't been thought through into practical effects. So if you're doing those sorts of point systems KPIs, they're great, but you've really got to work them through and think in practical terms, what would this mean on the ground? So there's no disconnect between what the lawyers are doing and what the commercial contract managers are doing. And so just finally and very quickly, onto the next slide, we'll look at remediable breaches. So as you'll know, a lot of contracts say a breach, you can terminate it if something has been breached, which, if capable of remedy, has not been remedied within 30 days. Some breaches are inherently remediable, some are not. So, for example, a breach of confidence is generally not remedied. Once the genie is out of the bottle, the genie is out of the bottle. But a late payment generally can be remedied, because you just pay the money with a bit of interest and then it's done. There's a question, can you terminate a contract for a breach that has been remedied? So it is possible, if a breach would otherwise be repudiatory, if the wrongdoing party leaps into action and does everything it possibly can to try and remedy it, by the time it comes to terminate, you may in fact have managed to remedy that breach. And when you're looking at whether a breach has been remedied, you're not looking at very precisely, has every single wrong thing been put back exactly as it was, because that's in practical terms impossible. What the court looks at, as per that quote on the screen, is the concept of capability of remedy must be directed to the question for whether the harm that has been done by the relevant breach is for practical purposes capable of being retrieved. So it's a slightly broad brush thing, but looking at the sort of the underlying substance, not every single dotted I and crossed T. So that's all I'm going to say about remediable breaches. It's a huge topic. There are loads of cases which often tie in with contractual interpretation points, and they often tie in with all other sorts of interesting contractual disputes. But termination is hugely important, and these clauses are central to it. So if you're going to take care of any clause in these sorts of contracts, termination clauses, rights to terminate, contract management are absolutely vital. Absolutely vital. You can't take them trivially. You can't just treat these as boilerplate. They're crucial to the effective operation and policing of the contract. That's all I have to say. Back over to Doug.
Thank you, Simon. I'm very conscious of time, so I'm going to cover the next topic in about a minute and a half, hopefully. The main message here is that no matter what type of organization you work in or the size of it, I can almost guarantee at some point there will be a contract that is lurking somewhere that you haven't found yet that will come back to bite you. And by that, I mean, we often see it when an acquisition has been made many years ago, or even maybe before the company or organization developed a sophisticated legal function, whereby there is a relationship on a very positive footing, working very, very well, but the actual underlying contract, whether that be a document or an exchange of emails, is not fit for purpose. If anything, is far from it. And the top tip here is try and identify or weed out those contracts whilst the relationship is on a positive footing, because it's much easier to regularize that relationship when you're getting on with each other and there's a commercial benefit to both parties, rather than waiting to look at the contract for the first time when a party tries to terminate or there's an alleged breach of that contract. And the other thing that I would say is that whether you do it by way of an audit or whether you just do a sample review of contracts, or even on a Friday afternoon, if you're a bit quieter with a cup of tea, you just pick out one or two contracts. You need to identify for your particular organization what your key areas are. And if you've got regulatory obligations, making sure that they are covered by those contracts with third parties, because the longer it goes on, if there's a long period of time that you're then looking back to that agreement, that the harder it is to unpick, the more expensive, and the harder it is to justify to your regulator that something wasn't done sooner. So that's all I'll say on that. But if you've got any questions, then please do follow up afterwards, and I'll pass back to Rachel. Thank you.
Just before we go back to Rachel, sorry, can I just say someone had typed in a question and I was going to try typing my answer, but I managed to press the wrong button, which said I was going to answer it live, and then I managed to delete the question. So I'm really sorry. So I will answer it live very quickly. The question was, if someone does a serious breach of a contract, but then sort of manages to remedy it, and then in the future they do another serious breach of the contract, but then manage to remedy it, does that sort of carry on ad infinitum? In theory, yes, because you look at the time you want to terminate. Has any breach been remedied? Is there a repudiatory breach at that point? So they could have done something serious and rectified it, and something else serious and rectified it. So if you want a contractual remedy to terminate in cases of repeated breaches which may have been remedied or which may amount to repudiation, you need to be just very clear in your drafting, because at any point of termination at common law, is there a repudiatory breach at that point? Sorry for deleting your question, incompetence on my part.
Thanks, Simon. Apologies for overrunning. I think we probably were trying to pack quite a lot into that session. So sorry about that. Thank you for those who hung on to the bitter end, as it were. We've lost a few, but most of you are still here. So I hope that has meant that we've given you some useful tips this morning. Thank you all for attending. Thank you to the team behind this webinar, Christine and Kate, who do all of the organising. Do please give us some feedback by clicking on the continue to survey button that will come up once we switch off the session. We're particularly interested to know what topics, obviously, you'd like us to deal with in the future. Thanks very much.